and so you're gonna have to show that intentional discrimination. After that case, Congress acted. This is something, unfortunately, Congress doesn't do anymore, but could when an adverse Supreme Court decision comes down, like the Bolden case. The Congress acted and said, no, that's not what we meant by the Voting Rights Act. We don't believe that intentional, obvious discrimination is the only thing we're trying to cover here. And in fact, they amended the language of Section 2, and you'll see it underlined here, to say that certain practices and standards and procedures are prohibited if they result in a denial or abridgment of the right of any citizen of the United States to vote. And so what that language is really intentional and really important. What it did was repudiate the prior Supreme Court decision that said, no, you have to show intent, and really was an effort to move the law to embrace much, much more than specific intentional discrimination. The point of that change that Congress made was to say, no, we want this law to cover results based cases. So cases in which there are changes to the law, changes to procedures, changes to registration, changes to, anything you can think of. If those changes result in a denial or abridgment of the right to vote, then that qualifies for action under the Voting Rights Act. Okay, so that change to Section 2, that results-based language, rather than a focus on the sort of subjective intent of whoever was implementing the practice, that was intentional by Congress. And it was after an adverse Supreme Court decision. Congress considered that decision and decided to change the language to make it more expansive and to really make the Voting Rights Act a powerful tool to fight back against these restrictions on voting. The other main section that you probably have heard of is Section 5. This works in tandem with, or did work, is past tense at this point, did work in tandem with some other sections of the Voting Rights Act. This is what's typically, or used to be known as preclearance provision, right? So at the time that this was passed, there were many, many states and local jurisdictions that had a long history, predominantly in the South, but in a wide variety of places across the country, including the Northeast, Northwest, all over the country. There were a number of places that had historically implemented a number of these provisions that suppress, Jim Crow laws and suppress the rights of Black Americans and others to vote on account of their race. So these were known as covered jurisdictions. There is a formula in the law that says these certain jurisdictions qualify for coverage. And the upshot of that was, under the Voting Rights Act, those jurisdictions could not make changes to their election laws, their registration, voting, couldn't adopt any new procedures, polling locations, precincts, any of that stuff. Those could not be adopted unless either the jurisdiction filed suit in court to prove that it was non-discriminatory and it wouldn't have a negative effect on the ability of Black Americans and others to vote, or more commonly, those covered jurisdictions would submit those proposed changes to the Attorney General of the United States. The Attorney General, Department of Justice would have a chance to weigh in on those. If they gave them the thumbs up, great, you can go ahead and implement that change. If, however, DOJ, the Attorney General, was of the view that it would result in decreased minority participation or otherwise burden the right to vote, particularly for minority voters, the Attorney General could essentially veto that and say, no, you're not allowed to enact that. So Section 2 and Section 5, there are other sections of the law as well, but Section 2 and Section 5 are really kind of the crown jewels of the Voting Rights Act. On the one hand, the covered jurisdictions and the pre-clearance mechanism made sure that jurisdictions that had a history of making it harder to vote for minorities and others could not adopt discriminatory practices. So that was the pre-clearance provision. And on the other hand, if there were other jurisdictions that were not covered by pre-clearance, or sometimes even in those same jurisdictions, Section 2 allowed the Attorney General and also private citizens to sue and file a lawsuit and say that these provisions are actually resulting in the denial or abridgment of the right to vote. So Section 5 and Section 2 worked in tandem. One was sort of prophylactic on the front end, one was sort of remedial on the back end. And for a long, long time, these were extraordinarily successful. You see over the history of the Voting Rights Act right after 1965, um, Black political participation in the United States, registration for voting really, really skyrockets. You see immediately within the next, 10 to 20 years, the proportion of people elected to Congress, people elected to local positions, mayors, city council, county commissioners, all of those kinds of things, were all you saw wide and increased participation, but also for the first time since Reconstruction, you saw the election of Black elected officials, not only across the South, but across the United States as well. And so that was a direct result of this law, because this law covers not just congressional elections, but it also covers local jurisdictions. So city councils, county commissions, if you're drawing lines, if you're doing elections, for example, Fayette County in West Tennessee, just a couple years ago, entered into a consent decree with the Department of Justice because the lines had been drawn in Fayette County such that it was an all-white county commission, despite the fact that over 25% of that county are Black citizens, and yet there were no Black county commissioners. That seemed to be a pretty direct result of the way the lines were drawn, and so Voting Rights Act provides a solution to that, and is now, of course, endangered, but as a result of the Callais decision. So I wanted to give that context to understand sort of what came next. For a long, long, long time, Voting Rights Act did its job. Black political participation, Black representation went up. There's a very deep well of case law around drawing districts. So there's a very seminal Supreme Court case called Thornburg versus Jingles, or Gingles. I think I've heard it before. I say Jingles. It's a matter of dispute among lawyers, from what I understand. That basically set out the criteria for how you go about deciding whether or not a congressional district or a voting district of some kind was unlawfully diluting the vote of minority members. You've probably heard about the terms packing and cracking. Those are two different ways that you can effectively take away the right to vote of a substantial minority population in a jurisdiction. Packing is, all right, we have enough, minority members. If they were spread across two different districts, then potentially they could elect two different people of their political choosing. But instead, what we're going to do is we're going to cram them all into a single district, so they get to elect one, but not two. Cracking is the opposite. You maybe have a cohesive group of minority members in a geographic location that are a substantial enough percentage of the voting population that they can elect their own, preferred candidate. And so to take away that power, and spoiler alert, this is what happened in Memphis last week, we will crack those people into different districts such that now they're spread out among different districts and they don't constitute a large enough basis to elect a candidate of their choice. So VRA was meant to deal with that. It was expanded to deal with a whole variety of ways to make voting harder for minorities in the United States. And for a long time, it did exactly what it was supposed to do. It was reauthorized multiple times by Congress. Most recently, just before the Shelby County decision, it had been reauthorized by Congress. It passed the Senate on a 98-0 vote. It was essentially unanimously reauthorized and expanded under President Reagan, reauthorized again under President Bush, and so just essentially was unanimously recognized as an excellent thing. Now, what happened? In 2013, there's a case, Shelby County versus Holder. So this is about the pre-clearance provision, so Section 5 that I was just talking about. Shelby County versus Holder was a direct challenge to that provision of the Voting Rights Act, essentially saying this is old and outdated, and yes, Congress reauthorized this law, but We don't think it should apply anymore. And Chief Justice Roberts, John Roberts, writing for the court, found Section 5 to be unconstitutional. Essentially, the short version is his argument, which he had been making since he was worked in the Justice Department many, many decades before, was that while he would at least agree that in 1965, when the act was passed, perhaps it was appropriate to place these restraints on states and jurisdictions. But by the time in 2013, the shorthand you hear is that Justice Roberts has declared that racism is over in the United States. We're living in a new day. Minority registration has soared, and so we really don't need this anymore. There's no real basis for Section 5. And so he led the charge to declare Section 5 and the preclearance provisions unconstitutional. And so as of 2013, the whole preclearance regime was wiped away. Two interesting things to come out of Shelby County versus Holder. One is, as Justice Ginsburg wrote in a very eloquent dissent, her criticism of the majority's opinion, which I think is right, was that it's like saying, I'm nice and dry because I have an umbrella, and the umbrella is working so well, and I'm so dry, so I'm going to get rid of the umbrella because it has worked so well. Of course, that's silly. If it's still raining, as soon as you get rid of the umbrella, you're going to get wet, and you're going to suffer the consequences. And of course, that's exactly what happened. A whole number of states, Georgia, Alabama, Texas, chief among them, including Louisiana, and a number of other states that were covered by Section 5 could not change their voting laws without DOJ weighing in. Literally, as soon as the decision came down, and this should sound familiar because we're living it again, as soon as Shelby County came down, these jurisdictions started passing incredibly restrictive voting laws, registration, line warming laws, getting rid of Sunday voting, getting rid of early voting, a whole slew of what I would consider basically anti-democratic restrictions on voting that they could not pass before because they were under this coverage formula. As soon as this decision came down, a whole slew of these laws were passed in all these states. And it was predictable, of course. Anybody who was watching this carefully knew that these states and the folks who controlled the legislatures and the governorships in those states were chomping at the bit and were ready to pass these things as soon as they possibly could. And it came to pass. It's exactly what Justice Ginsburg predicted in her dissent, and it's exactly what happened. So that gives us an eye towards like what's going to happen in the future when these decisions come down. The other part I want to point out, and I have it highlighted here from the opinion, is that Justice Roberts and later Justice Alito does the same thing, tries to present this decision as an incrementalist decision, right? He says our decision in no way affects the permanent nationwide ban on racial discrimination in voting found in Section 2. Keep that in mind. 2013, it's okay. We're getting rid of preclearance. We're getting rid of Section 5, but it doesn't affect Section 2. Section 2 still says you cannot be denied the right to vote by any procedure or device or anything like that on account of color. And so we've still got that in place. So don't worry, this is not going to have a huge impact. I think what was John Roberts trying to convey there. Of course, that was an empty promise. I suspect he knew that at the time, given how things have played out over the last 15 years. But it's in there. It's in the sort of assurance section. So that's Shelby County. That's 2013. Over the next few years, as I said, we saw the advent of all of these restrictions on voting come into play, particularly in the South, but elsewhere as well. Fast forward to 2021, and there was another case called Brnovich. This is a case out of, it came out of the Ninth Circuit, and it had to do with state laws on how easy it was to vote or not. And so particularly In this case, there were groups of Native Americans, many of whom lived on reservations, and so there were originally some carve outs for how those folks got to vote because the mail service was not very good. There were no precincts that were convenient to come vote in person. And so there were some laws on the books that made it easier for particularly people, particularly Native American families and voters living on reservations to vote in a different way. A different party came into power, reversed those restrictions, reversed those exceptions. And the upshot was for certain members, for certain citizens, it became a lot harder to vote. Really a lot harder. Like think about driving hours and hours to go find a precinct to vote in person because all of the other exceptions have been wiped away. This these laws were challenged under Section 2 of the Voting Rights Act. And Justice Alito wrote the opinion on behalf of the Supreme Court and basically said, listen, um, Section 2 does allow challenges to so-called time, place, and manner restrictions. So traditionally, there were a lot of Section 2 Voting Rights Act cases that were focused on districting. So what we just talked about, drawing district lines, congressional districts, state districts, county commission districts, that Jingles case that I mentioned, that's all about drawing lines and sort of who votes for whom and gerrymandering and all that. There also were lots and lots of restrictions and litigation about time, place, and manner. So how are you able to vote? What options are you given for absentee voting? What options are you given for early voting? What about mail-in voting? What about ballot, drops like drop boxes? There are all of these different ways that states can restrict or enlarge the ability, make it easier, make it harder for people to vote. And this was a challenge to those laws, saying this this state is making it too hard for these folks to vote, and that is resulting in um, a an abridgment of the right to vote on account of race or color. And you'll see here that again, Justice Alito in this case actually sort of makes up a test. There hadn't been a lot of development of this case law on time, place, and manner restrictions, but he sort of creates this test out of whole cloth, saying, well, you got to look at what is the size of the population being impacted. How burdensome is this law on that population? Do they have other ways in which they can vote? Are there available alternatives? None of which is in the case law, none of which is in the statutes. And then there's a big criticism of this opinion to say, Justice Alito was just making a whole new test up, not based in the statute, not based in the history. But what I point out again is this language. You find an echo of it in the Shelby County case, and you see it again here. Justice Alito says, and he quotes the and puts in italics the language from Section 2. 2A substitutes the phrase. So he talks about the Supreme Court case that originally construed the Voting Rights Act narrowly. Congress responded to the Bolden case and said, no, the Voting Rights Act is supposed to be very expansive. And he says, in place of that language, Section 2A substitutes the phrase in a manner which results in, and he put those italics in there, results in a denial or abridgment of the right to vote on account of race or color. Now he has a little signal there. We need not decide what this text would mean if it stood alone. And then he goes on to say, well, Section 2B modifies this, and so yada, yada, yada. But again, this is an effort by Justice Alito to, in effect, what he's doing in this Brnovich opinion is to really, really make it much harder to challenge voting practices under the Voting Rights Act. He's saying, well, you have to prove all these things, that it's a really widespread and it really impacts a lot of people and there's no other viable alternatives, all these sort of like stumbling blocks towards proving your case and really making it much harder to bring these cases. But he says, no, it still says results in. That's what it says. That's what Congress intended. So you can still bring these claims, but now you have to jump through all these other hoops and, prove these other things in order to bring the claim. But you can still bring the claim. And that was Brnovich. The Brnovich was correctly seen at the time as yet another sort of chipping away at Section 2 of the Voting Rights Act now that Section 5 was gone. Didn't get rid of it, but certainly made it much harder to bring those lawsuits because now you had to comply with this made up test that Justice Alito made up. And so I think a lot of folks saw the writing on the wall. Brnovich was yet another in a series of chipping away or slowly burning down the Voting Rights Act. So you fast forward to what everybody saw coming, Louisiana versus Calais. There are some other cases that are sort of in between. This is actually part of a series of cases. There was an original Alabama case. There was a whole other case coming out of North Carolina, uh, Moore, which had to do with this really, really off the wall independent state legislature theory, which would have said that states can just do whatever they want with their maps whenever they want, and it's not reviewable by any court at all ever. Thankfully, the Supreme Court rejected that theory, although it is still bouncing around the more authoritarian wings of the legal community these days. So we may see it come back. But what we have is in Louisiana, what we have in this Calais is really the court finally finishing its demolition of the Voting Rights Act, in particular in the prime piece of what the Voting Rights Act did, which is deal with congressional and other sort of electoral districts, right? So for years and years and years, um, you know, the pre-clearance provisions that were knocked down by Shelby County versus Holder, those were really guarding against, the poll tax, the literacy test, the sort of like obstacles to make it hard to vote. And so as a result, a lot of jurisdictions and states had pivoted away from, all right, we know we can't do that anymore and make it hard to vote at the ballot box because we have to go through this pre-clearance stuff, and we're also subject to Section 2. So instead, we're going to just gerrymander the heck out of our states and out of our jurisdictions, and we're going to pack people and we're going to crack them, and we're just going to make it hard for them to elect. They can still vote, but their vote doesn't really matter because they can't elect who they want to elect, right? And so the terrain of voting rights litigation had shifted, particularly in the 70s and 80s, towards focusing more on this sort of gerrymandering vote dilution claims. And this is the culmination of that. So essentially, the argument under Section 2 for vote dilution was exactly as I said before, the packing and cracking thing. Um, the whole body of law leading up to Calais that had been developed over time basically said, look, if you have a reasonably compact group of citizens who are all the same race, or you can also have these sort of like coalition districts. So you'll have, a large group of Black citizens and also a large group of, Native American citizens or Hispanic citizens, and they all sort of vote together. If you can show that you have a reasonably large group, that they are relatively geographically compact, and that if they were placed in the same district, that they would either be able to elect a representative of their choice, they would have sufficient political power to elect a representative of their choice outright, or potentially an opportunity district, which is, well, maybe it wouldn't be enough, maybe the numbers wouldn't be high enough for this minority group to elect a representative of their choice outright, but if they represent a sizable enough chunk of the electorate in this district that if they can combine with sort of like-minded voters, like-minded white voters or like-minded voters of another group, that coalition will be enough for them to elect a representative of their choice that's an opportunity district, then that should be, that is important. Because the whole point of this is the 15th Amendment. The 15th Amendment is to empower minority voices in the United States, and for Congress to be able to enact legislation that makes sure that minorities have a voice in the political process, even though they are a minority numerically in the country. The whole point of the 15th Amendment and the Voting Rights Act is to make sure that those folks still have a potent political voice in the process. So the way you do that is you say, okay, if you can meet these certain criteria, these jingles criteria, then we are going to tell these states you need to draw districts in a way that makes sure that these folks have political power. You're not allowed to crack them. You're not allowed to pack them. You need to draw districts such that, for example, in Alabama, um, the black population is big enough as a part of the statewide whole and compact enough to where if you were drawing districts, probably two out of the districts in Alabama should be majority black districts or should be, opportunity districts where the black Alabamians can elect a candidate of their choice just based on the numbers. And so the Voting Rights Act under Section 2 said you have to draw the districts that way. So that was the law for a long, long time. Alabama had actually, a group of citizens had challenged the Alabama maps, saying there's only one uh, district in Alabama that is sort of a majority minority district and where a black candidate can be elected. But given the numbers and the demographics in Alabama, actually there should be two. There should be a second one. That case went up to the Supreme Court. The Supreme Court actually agreed, much to the surprise of a lot of us, and said, yes, that actually makes sense. A three-judge panel had this extensive finding of fact and trial and showed why it satisfied the jingles factors. There should be a second majority minority district. So that case had gone back down. Alabama had refused to implement its map, and then Louisiana did something similar. And so then those cases made their way back up again to the Supreme Court. Um, and this time, the court, Justice Alito, again writing for the majority, decided to take a wrecking ball to the remainder of the Voting Rights Act in a way that is just so, in my own personal opinion, nakedly partisan, contrary to law, contrary to fact, contrary to history. And what I've highlighted here is that, and this is just in the first paragraph of the opinion, Justice Alito says, unfortunately, lower courts have sometimes applied this court's Section 2 precedents in a way that forces states to engage in the very race-based discrimination that this Constitution forbids. That sentence in and of itself is so ahistorical that it really boggles the mind sometimes. And Justice Ketanji Brown Jackson is excellent at this. She has really gone out of her way over the last several years during oral argument and in her dissents and concurrences, and whenever she gets a chance to write, to point out the fact that the 14th Amendment, the Civil War amendments, the 14th Amendment and the 15th Amendment particularly, they are remedial amendments to the Constitution. They are race conscious in a positive way. The whole point of those amendments was to recognize the great sin of America in its system of chattel slavery and recognize that that needed to be remediated. That's what Reconstruction was about. That's what the 15th Amendment and the 14th Amendment are about, is remediating that. And you have to take race into account. It is explicitly in there. It's in the text of the amendments. So the idea that Justice Alito and Justice Roberts and several others have been pushing, that sort of the Constitution is race blind and it is anathema. You often hear it said that sort of race is anathema to constitutional law, is just wrong. It's just wrong as a matter of case law. It's wrong as a matter of history. It's wrong as a matter of just reading the plain text. But it is a political agenda that this, in my opinion, that the majority of the Supreme Court has been pushing, and you see it has come to its sort of final apotheosis here in this opinion, where Justice Alito says, "Well, actually, what Section 2 has been doing is forcing these states to draw districts based on race, and you can't do that." Which is just again wrong and ahistorical. But that is the way that the court has used the history to effectively strike down Section 2. So I want to tell you sort of what that means. Now, this opinion does not actually strike down Section 2, which is another sort of clever move by the court. It would be one thing if the court said, well, just like in Shelby County, there, Justice Roberts said, yes, Section 5 is unconstitutional. Full stop. It's gone, like cut it out of the law. But don't worry, Section 2 is still there, is what he said. Here, the majority says, well, Section 2 is not necessarily unconstitutional, but actually, the last 60 years of Supreme Court precedent has been interpreting it wrong. And so, what Justice Alito says, contrary to what he said in Brnovich, contrary to what Justice Roberts said in Shelby County, uh, where they just said, oh, yeah, of course, right? So, Congress passed the law. There was a Supreme Court case, Bolden, and then Congress said, no, no, what we meant was it's focused on effects. It's not just focused on intentional discrimination. Justice Alito in Calais does a full about face and says, actually, no, what you have to prove under Section 2, if you're gonna get a remedy, is you have to prove intentional discrimination. And he tries to couch it and says, well, you don't actually have to have like smoking gun proof of intentional discrimination, but you do have to have circumstances giving rise to a strong inference that intentional discrimination occurred. So what does that mean, right? What that means is that prior to this case, if folks wanted to bring a claim, a vote dilution claim, they could use these jingles factors, and you can see Justice Kagan quotes it in her dissent. You could say, look, the totality of the circumstances, the history, the geography, the way people vote, all of these taken together, and the effect on this law, the effect of this law, all that taken together shows that yes, this results in, remember, those are the key words, results in denial of an equally open opportunity to elect people of your choice. So it's the focus on the results. What's the endpoint? You do not have to show specific intent. You do not have to have a smoking gun email. And why? It's because people have gotten smarter over the last 60 years. Racists have gotten smarter. They don't say the quiet part out loud anymore. Very rarely, you are not going to find direct record evidence of intentional discrimination because, and pardon me a little bit here, but even the dumbest racists out there have mostly figured out, if they've gotten to an elected official position, not to say that stuff out loud. They will just say, well, no, I'm doing this for this reason, I'm doing this for that reason. They've all been trained, and they don't say it anymore. What Justice Alito has done in this opinion is to say, well, you still have to find evidence of intentional discrimination. You have to show intent. And if the legislature can come up with any other reason why they're adopting this map, sure, we're splitting up Memphis into three different pieces, but it's not about race. It's about partisanship. It's about wanting to elect more Republicans. It's not about race. If that is what the legislature says, and you cannot find any countervailing evidence of intent, then the map stands. Because another piece that I don't cover here, and you should look at if you're interested in this topic. There's another case called Rucho versus Common Cause. That's a Supreme Court case where the Supreme Court ultimately, after Justice Kennedy retired, finally put down the decision that said we can't touch partisan gerrymandering. We know it's bad. It results in some terrible things for our democracy, but we have decided as a Supreme Court, now that the swing vote is gone, that this is non-justiciable, which means that if states want to gerrymander the heck out of their state, if they want to say, you know what, we have power, we don't want anybody from the opposing party to get elected, you can draw the lines however you want, however goofy they look. That Rucho versus Common Cause opened the door for that kind of thing. And now combined with this opinion in Calais, all a legislature has to say is, look, we're just trying to gerrymander the heck out of this state to try to maximize the number of, our party that gets elected, right? So those two things work together to basically give the green light to anything a controlling party wants to do in a state, and make it virtually impossible to bring a Section 2 vote dilution claim, because under this opinion, you have to show effectively intentional discrimination. It has now switched. It used to be that if there was evidence tending to show that minority voters were being diluted, then the state had to come up with a reason, had to show a rationale as to say, no, 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 that's not actually what happened. Now it's flipped. As a result of this opinion, and you saw this in the South Carolina case from a few years previously, this Supreme Court wants to give every single benefit of the doubt to the state legislature, presume that whatever the state legislature has done is fine, and it is now on the plaintiffs. They face a really steep hill to try to prove intentional discrimination, which, again, because nobody says the quiet part out loud anymore, no one is ever going to be able to do. So, in effect, the Supreme Court in Calais said, we're not killing the Voting Rights Act, but in effect, that's what they were doing. I certainly urge people, and I want to move on so that I can talk about Tennessee cases first for a minute. Certainly urge people to read Justice Kagan's dissent. She very firmly puts back on Justice Alito the idea that, yes, it's supposed to, Section 2 is a results-based, not an intent-based section. And she says, under the court's new view, and she's right, this is a new view, under the court's new view of Section 2, a state can, without legal consequence, systematically dilute minority citizens' voting power, which is, of course, what we're already seeing. And then I noted also in this other piece of her dissent, she tracks exactly what I've been talking about. Today's ruling is part of a set. For over a decade, the court has had its sights set on the Voting Rights Act, and she talks about finding Section 5 unconstitutional in 2013. Then she talks about, of course, not surprisingly, a flood of discriminatory voting laws followed. And then only Section 2 stood in the gap. 2021, the court did half of what was needed to raise that Section 2. And she talks about Brnovich, and she concludes Calais as the second half, and it finishes the demolition of Section 2. So where are we? Well, for all intents and purposes, unfortunately, Voting Rights Act is dead. There were many ways. There's still some legacy pieces, and maybe there's an extreme, scenario in which you could bring a Section 2 claim. But for all intents and purposes, the Voting Rights Act is not going to do much in its current state with the current court. And just like you saw after Shelby County and Brnovich, you've now seen a flood of discriminatory maps being introduced. Tennessee among them, but also Florida. Louisiana is working on its map. South Carolina just announced today that it is going to try to draw Congressman Clyburn out of his district and get rid of the only black elected congressman in South Carolina. Governor Kemp just called for a special session in Georgia, so they're going to try to do the same thing there, presumably to go after black elected officials in Georgia. So you're seeing a flood immediately after the decision. Thankfully, as soon as the Tennessee legislature last week had its special session, I'm sure everybody on this call followed that, and I really appreciate Adam. Adam was there in person for most of what was happening last week, helping monitor and cause some good trouble there. But in addition to all the protests and everything else that was going on, there have been now 3 lawsuits filed in Tennessee, and they are all challenging sort of different aspects of the way this map was passed. The first one to be filed the same afternoon that the governor signed the map was filed by NAACP. Former Kristen Clark, formerly of DOJ, is now leading NAACP's legal arm, filed this in state court here at Chancery Court in Nashville. On a really interesting and I think a unique and smart way to go about it. The way that the map was adopted was during a special session, which we all know. The way that happens in Tennessee is that the governor has to issue a call for a special session and has to say in that call, what is the purpose of the special session? What are we here to do? And you are only limited under the law to doing things that fit within that call. So if the governor calls a special session to redraw the maps, you can't go about and then pass a new law having to do with, agriculture or something like that, because that's not within the call. What happened was, I think the majority party did not realize that this law was on the books, or maybe they realized it too late. But Tennessee had, or maybe still has, a law on the books, 216-102, that specifically forbids mid-decade redistricting, drawing the maps mid-decade. And that was on the books and still in force and prohibited the drawing of the maps. So what happened during the special session is a new bill was introduced before the map was adopted to repeal that law. And then once the repeal was voted on and signed, then the legislature moved on and passed the new maps. What this lawsuit challenges is that law, 216-102, was not mentioned in the call for the special session. It's not part of the proclamation. It's not mentioned anywhere else. And the argument here is that was actually something that the Tennessee legislature was without the authority to do. They could not repeal that law during the special session because it was not within the call. And if therefore they could not repeal that law, then it's still on the books, and mid-decade redistricting is illegal. And I actually think it's a really interesting argument. The case law is pretty good on special sessions and the call. Given our judiciary here in Tennessee tends to be a little more conservative, maybe a long shot altogether, but I think it's a really smart first shot. So that's filed in state court here in Nashville. The second case, filed the same day, I think close to midnight, if I recall, was filed in federal court. So this is also here in Nashville. This is the Tennessee Democratic Party, as well as a number of citizens and just as importantly, candidates filed this lawsuit. So you'll see in the caption here, among the plaintiffs is Steve Cohen, Justin Pearson, and Chaz Mulder. Of course, Justin Pearson and Steve Cohen were running against each other in the Democratic primary for the 9th Congressional District in Memphis. Steve Cohen is the current congressman from Memphis. Chaz Mulder was running in a different district, challenging current incumbent Andy Ogles. They had all spent a bunch of time and money on their campaigns, getting ready for the primary. And this law changed deadlines and, in fact, moved specifically these candidates out of their districts. So now Cohen and Pearson are no longer in the 9th, which is what they had originally qualified for. Mulder is no longer in his district, which I think was the 5th, which is what he qualified for. They were all specifically targeted, is what the allegations in this complaint are, and moved out of their district so that they couldn't effectively run a campaign anymore. The deadline to decide which district they're going to run in is Friday, 2 days from now. And that is a real problem because they have to decide, do I run in the district I'm already qualified in? For Mulder and for Pearson and for Cohen, I believe, if they continue to run in the district that they qualified for, they actually can't vote for themselves because they don't live in that district anymore. And so they're left with this conundrum of what do I do? Do I pick a new district and have to start my campaign over effectively? Or do I continue running in this district? And if I win, maybe I have to move to this new district that I'm now drawn into. Taken together with the fact that, and this is the case I also worked on back in 2022, there was a challenge to the state, House, and Senate maps. So think about the state legislature back in 2022 after the lines were redrawn. The Democratic Party worked on that case, and I sort of helped some of the lawyers who were the same lawyers in this case challenge those maps because they were unconstitutional under the Tennessee Constitution. We got an injunction, but the Tennessee Supreme Court in April of 2022, so that was a midterm year, just like this one, the Tennessee Supreme Court reached down and stayed the injunction on the basis of proof from election officials, including Mark Goins, who's the coordinator of elections for the state of Tennessee. They had submitted affidavits that April of 22, so April before the midterm, was too close to the election. They said, this is going to cause chaos. We can't draw new maps. It's too late in the cycle. We're not going to be able to get ballots to voters. We're not going to be able to get notice to voters, all these things. And so now, fast forward 4 years, we're in May of a midterm year. And election officials and the folks who are running the legislature say, no, it's not too late. We got plenty of time. And so this lawsuit is saying, you can't have it both ways. You said 4 years ago that April was too late, sworn affidavits, and now you're saying May, even later, is just fine? That doesn't make any sense. That's contradictory. And we all know that that it is in fact too late. We are too close to the primary. We're too close for these maps to go into effect. and it puts these elected officials and candidates in a position, an untenable position to make a decision. And so in this case, the parties have moved for a temporary restraining order and a preliminary injunction. They are trying to get the court to enjoin the maps and basically say, nope, for 2026, this map is not going to go into effect. It's too close to the election. You need to put everything back the way it was, and then we'll continue litigating the case. And maybe the map will be constitutional on down the line, but for now, for this election, you need to enjoin the map. Uh, I think they were hoping to get a ruling on that this week. I know they were hoping on getting a ruling. It seems like the judge, Judge Campbell, is not inclined to issue a ruling by Friday, which is what the candidates were hoping for. There's a hearing on the temporary restraining order set for May 20th. And so that is giving the state time to respond. So the briefing is ongoing back and forth right now. There were some additional uh, election officials who submitted affidavits on behalf of the plaintiffs saying, yeah, it really is too late. Montgomery County, for example, under the old map, it was within a single congressional district. Under the new map, it is split between two congressional districts. So Montgomery County and Williamson County and a number of others, Davidson County, Shelby County, they're going to have to completely redo all of their precincts, all of their ballots. You can imagine where, if people are coming to a precinct, you might have some people who are in one congressional district, some people who are in another. Sorting that out, being prepared for all that is a huge mess. And usually they have months and months and months and months, if not years, to figure this out. Now they're on this insanely compressed time frame, and they are arguing that is going to end up disenfranchising a lot of people and causing voter confusion. The last lawsuit, this Sherman case, was filed May 11th, so 2 days ago. This is ACLU, ACLU of Tennessee, and ACLU National filed on behalf of a number of individual voters, plus the Black Clergy Collaborative of Memphis, the A. Philip Randolph Institute, and Equity Alliance as plaintiffs, essentially taking direct aim at the maps themselves. And so, urge you to read this complaint. It is really both narratively compelling. These are just the first two paragraphs in the complaint, but also really well supported in terms of the fact that, notwithstanding the Callais decision, this map that was drawn to crack the Black voters of Memphis is in direct violation of the 14th and 15th Amendments. They are taking direct aim at the map itself. They filed a motion for TRO, I think it was today or yesterday, and have at least 3 expert witnesses who have submitted reports already saying, here's how this map is discriminatory, here's the effects it's going to have, here's, if you wanted to do partisan gerrymandering, you could have done it this way and avoided cracking all these Black voters. And so, just like the other federal case, the plaintiffs here have moved for a temporary restraining order, trying to get the maps blocked for at least this campaign cycle. And then long term, the idea would be that these maps are unconstitutional because they violate the 14th and 15th Amendments. And so this is, again, taking a little bit a different take on it, but driving towards the same relief, which is to try to overturn the map. So you've got the state court case focused on the special session and the call. You got what I'm calling sort of the candidates case, focusing on sort of the effect on the candidates and the effect on the voters and sort of how close to the election we are. And then we have the really sort of core 14th Amendment, 15th Amendment constitutional case, which challenges these, basically saying, look, and if you read the complaint, you see this is an attempt to really demonstrate the kind of racially motivated intent that now Callais purports to require for these kinds of claims. So it's a really compelling complaint, extremely well written, really well researched. We have a really a great team at ACLU working on this, and then some of the lawyers from ACLU National. I'm actually co-counsel on another case in DC. I know them, and they're great. We've got a great set of plaintiffs. So all 3 cases are currently pending. I think probably the candidates case is going to get to the TRO decision first, just because they were filed a little earlier and they also sort of have things on a quick track. So we're hoping, within the next week or so, we're going to get a ruling. I am not necessarily holding my breath that we're going to have a brave federal judge decide to enjoin these maps. If we do, um, it could get appealed straight to the Supreme Court. There's a federal statute around redistricting cases have to have this three-judge panel appointed, and it looks like probably both federal cases are going to end up with a three-judge panel. And the way that works is if you get a ruling from the three-judge panel, it can be appealed immediately to the Supreme Court. And on the defendant side, representing the state is a national law firm, Consovoy, that does a lot of this work on behalf of states. And so we remains to be seen what's going to happen. But I think these groups and these plaintiffs and these lawyers who are working on these cases have really done an excellent job at taking kind of the best shot that they can, given the circumstances, given how compressed the time is right now. And so I think we're all hopeful that one or more of these cases succeeds, and at the very least that this map gets enjoined and blocked for this election cycle. And we'll see what the long term holds. So I know I'm right out of time. I apologize. I'm a lawyer. I like to talk. So I'm happy to hang on for a few minutes if folks have questions. I also wanted to put this up there, and I can throw it back to Adam as well. But Organized Tennessee and Protect Democracy the same has recognized that this midterm coming up is one of the more consequential elections we've got. Where we fully believe we're going to see attempts to interfere at the polls, at voting locations. We're going to see attempts to deny the results if they're bad for the administration. We're going to see disinformation. We're going to see all these things. So it's really, really critical that we have lots and lots of poll observers, neutral poll observers, who are there to make sure that people are able to vote and to push back on some of these authoritarian tactics. So if you haven't signed up, you haven't done the training, it's great. I've done it. It's real easy to learn how to be a poll observer. It's a great way to get involved in the process. So scan that QR code and you can sign up for training. Other than that, like I said, happy to hang for a few minutes if folks have questions. And I appreciate your time today.
Hi, everybody. All right, everyone give it up for John, who did a great job educating us on a really complicated and technical subject matter. So thank you, John. John, I think, does one of these every quarter with us, it feels like. And yeah, I think you did it the last time on this very same case before we came to the Supreme Court. So I know a couple people have some questions. I'm going for all of our attorneys out there. This is your chance to get your hours that you need to keep your license. So if you want to continue practicing, fill this out, please. And we will get you taken care of. We will submit that on your behalf. And I will do another thing. I'm also going to put it in the chat. Um, it's our volunteer interest form. It allows you to sign up for a bunch of different things, including fighting for fair maps, joining a county team. And so we're going to be building hopefully some infrastructure here over the summer where we can like really address these maps, right? Because we talked about for an hour today on redistricting. Every state has a unique process. Ours looks a lot like other states, but we're in some ways very different, right? And one of our goals is to do a lot of public education for advocates and individuals like y'all, so that y'all can be the folks going to the legislator and fighting for this, right? That's kind of what we need to do as a movement in the long run, is to build capacity of everyday individuals who care about our democracy, who care about the rules, so that we can have in the type of state that we want, right? So I will. That's my plug to do this interest form. And I think we have a couple questions. So I'll go to Virginia first because I saw her hand up first. So Virginia, take it away.
Yes, sir. Thank you for coming and speaking to us. I want to know, how will these lawsuits affect what Cameron Sexton did either yesterday or today, where he removed all the Democrat people off of different committees? So now
That's a
we don't have full representation now because they don't have their committees.
Right. It's a great question. So these lawsuits don't directly deal with that. That's sort of more a state law claim under our state constitution. I can imagine at some point, there were similar efforts when Justin Pearson and Justin Jones were expelled from the legislature, and then they were sort of brought back but kept off committees. Generally speaking, the majority seems to have backed off on that last time. They may do so again. It may be sort of a without getting too partisan here, a little hissy fit that they may back off on at some point. But if they don't, I think you can imagine Eric Holder, our former Attorney General, actually was in ongoing conversation with both Justin Pierce and Justin Jones last time after they expelled from the legislature, potentially about bringing a lawsuit over that. So I would suspect that if, yeah, they're not reinstated to committees or not added to committees, you could potentially see Eric Holder and his law firm either threaten to bring suit or bring suit, is what I would expect. So we'll have to see, yeah, if they get reinstated or not. It's a good question.
Okay, thank you.
Sure.
Did anyone else have a, I know a lot of people jumped in. Any other questions? We have some time, so no rush.
I have something that's not directly related to the lawsuits about voting locations. The number of voting locations in the metro area are basically two or three. And if when I took my daughter and my son out to get their learning permits a number of years ago, I mean it's a minimum of 2 hours. In one case, it was like 4 hours. And this is actually, I'm almost positive this is a voter suppression tactic. They don't increase, yeah, and the location of these, like stations, like car stations, it's kind of in the middle of nowhere. It's difficult to get to unless you have a car. The parking is horrible. The size of the facility is such that people are packed in, and we actually ended up going out to Lebanon in one case and got in and out in like less than an hour. And Lebanon actually just expanded their facility. So is there anything being done to address this, to increase the number of locations where people can get a picture ID?
So it's interesting because what you're pointing out, is something that conceivably might have fallen under the pre-clearance provisions. So voter ID, for example, would have fallen under the pre-clearance provisions that were struck down in the Shelby County case, right? So there was not a ton of widespread voter ID until Shelby County got rid of pre-clearance, and then lots and lots of states, including Tennessee, adopted it. So those are the kinds of things that normally would have, DOJ would have weighed in on. Voter ID itself, but also ability to get proper ID. Unfortunately, unless a new version of the Voting Rights Act is passed by Congress, it really comes down to political control of the state legislature. So, they can make those rules and they can cut down voting locations. They can make it harder to vote. They can shorten early voting. They can delete early voting altogether if they feel like it. And so it's really a political contest at that point because there's no overarching regime here. And I responded to another comment in the chat as well. Part of the other problem is that even if a more pro-voting, pro-civil rights coalition took control of Congress, you still have a really recalcitrant Supreme Court at this point. So I think it's going to be table stakes if we want to fix voting and fix democracy in the United States. I think Supreme Court reform has to be first and foremost on the table. I think anything a more progressive Congress would do would be immediately struck down by the Supreme Court majority, and so they go hand in hand. Wish I had better news, unfortunately, but
it's an honest answer, so I appreciate that.
Sure.
I have a question. Do we, especially Calais, not necessarily the state, is that applicable to the local municipalities, to your cities, to your towns?
Yes. Unfortunately, yes. So, and that's actually, if you talk to some voting rights experts, that is actually where a lot of folks are worried the most pernicious impacts are going to be. Because before Calais, I sort of said at the beginning, the redistricting decisions, the ones that get the most headlines are Congress, but the ones that actually matter the most in a lot of respects are like the local jurisdictions. So county commissioners, city council, school board, like that kind of stuff, like the Fayette County example, right? And so before, you couldn't pack and crack folks within a county. Um, and now with Calais, I think you're going to see a ton more of that at the local and municipal level, which is extremely worrying. It's going to lock minorities out of power at not only the state and national level, but at a local level as well, which is where most of our government, services are located. Um,
I do want to, but so what happened in Calais is not an isolated incident. It is part of a longer playbook, right, of authoritarian consolidation. So, John, maybe you could, because I know Protect Democracy does this work. Like, how does, like, let's put voting rights and Louisiana v. Calais in a context of like some of the other bigger picture things that this administration and other folks are using to kind of insulate them from the mechanisms that could hold them accountable. Like, how does this fit with the big picture?
yeah, it's a great question. So part of the issue here is that at the same time that you have a real dysfunctional Congress that won't act to check the president and his prerogatives, you have a Supreme Court that has really, really increased massively the power of the president and the executive branch. And so the majority on the Supreme Court and cabinet level officials on down in the current administration have gotten on this idea, this legal theory called the unitary executive, that essentially says the president, everything begins and ends with the president. And if it has anything to do with sort of like not anything, if it's not lawmaking, that Congress does that, but everything else the president does essentially. And the Supreme Court has backed him on that. And so that's why you have seen all this flurry of executive orders and DOJ taking these actions, sort of aggrandizing the president. And frankly, I will say this has been a long, long evolution over multiple presidents of both parties. The Obama administration really, really pushed the limits of executive power. Bush administration for sure did as well. Even the Biden administration, in some respects, did as well. And so you have seen this massive rebalancing in power in the United States. Whereas if you look at the original conception of how the Constitution is set up, the legislature, Congress, is kind of the primary branch, right? And the executive is supposed to carry out the laws, but really the executive is supposed to be following the instructions of Congress, right? Congress makes the laws, judiciary checks. But now you've seen this massive rebalancing to where the executive, the president, has all of these powers, and Congress doesn't do anything to check him. This Congress isn't doing anything. And so that is really why you see the rise of these authoritarian tactics. And unfortunately, you're supposed to have two other branches that act as a check on the president. It's supposed to have the Supreme Court saying, no, no, you don't have the authority to do that. You don't have the power to do that. But the Supreme Court's not doing that. They're just giving the president sort of unlimited power to do whatever he wants. And you're also supposed to have the Congress checking the president in a variety of ways. But this Congress has no interest in doing that, even though the president is overstepping and stepping all over congressional priorities and prerogatives. You don't have a Congress that's acting to check him either. And so what you really have is the development of this unrestrained executive, unrestrained presidential office that is, agglomerating more and more power to itself, arrogating more power to itself. And that's, I think, why you see the rise of authoritarianism, and it's why it's so dangerous in this country. And so you need a Congress to push back. You need a Supreme Court to push back. But frankly, and we study this a lot at Protect Democracy with our partners, the one thing that pushes back against authoritarianism is mass mobilization across the country and across political classes and across socioeconomic classes. Like mass mobilization in other countries that have dealt with authoritarianism, that's what works. And that's what you saw in Hungary. It took a long time, but Orban was defeated. And that was specifically because all members of society came together and said, look, we're going to unite behind a single candidate, even though that was a center-right candidate. The progressives and the lefties all said it is better for our country that we come together to get rid of this authoritarian, and we will go back to our own little parochial interests after we get rid of the authoritarian, right? There'll be a robust democracy again. But we have to be able to do it. You saw it in Poland before that. You've seen it in Zimbabwe. You've seen it in a bunch of other countries. But really, I hate to say this as a lawyer, but the courts are not going to save us. Lawsuits are necessary, but not sufficient. Mass mobilization, mass action in support of democracy and against authoritarianism, against authoritarianism is really what's gonna do it. And I'm really proud that Organized Tennessee is a huge part of that.
And to John's point, like there was research done that like over the past 30 years, like countries that have gone into what's called democratic backsliding, which is like some of the norms of our democracy are eroding, like that idea. America is certainly in that category, but 80% of those countries who have had some level of democratic backsliding have rebounded and they've actually come back even stronger, right? And
Right.
so there is like a path here, and I'm going to be really shameless because Organized Tennessee is part of that effort, and we are investing in a Shelby County organizer that is going to be focusing on voter turnout and election protection in Shelby County. So if you or anyone you know like are interested in really diving in this, like on the ground level in Shelby County, there's a job description I just put in the chat. Would love for y'all to apply. We're going to start interviews probably in the next week or so. So if you or anyone else, you do have to live in Shelby County. This is a geographically based. So if you live in Shelby County or you know someone there that wants to get on the ground to do election protection, voter turnout in a really important year, please would encourage y'all to apply. So that's my shameless pitch and a great pivot, John. Thanks for giving me that.
Absolutely.
And I think we have time for one more question, and then I say we close out.
I think that's right. And I'll just flag too, as this stuff develops, I think, Adam, this is off the top of my head. I'm more than happy to do another one of these things as things develop. So, stay tuned. If you haven't signed up for the Organized Tennessee mailing list, please do that so you get notified of this. But we'll do this again as things continue to progress. So yeah, one more question if anybody has any.
Adam, what's your last name?
Mine, Altendorf. I'll put it in the chat.
Okay.
All right, Celia, go ahead.
All right, couldn't come off mute.
Yeah.
Thank you again for this. Since you mentioned some of kind of the other, executive orders and threats, there's so much going on, trying to keep our head on the swivel. Is there any update on the Senate's progress with the SAVE Act? And is there anything that, any implications yet? Like, do we think that's going to be this session, or is it stalled until the next session?
So PD is PD, Protect Democracy, where I work, is tracking this very, very carefully. And we have lots of friends on the Hill. Our information at this point is that it is essentially dead, which is great. I'm sure there will be attempts to revive it. What the administration has pivoted to, and this is a case that I'm actively litigating right now with my colleagues and a bunch of partners, is you may have heard the Department of Justice sent requests to all 50 states and the District of Columbia demanding that they provide their full unredacted voter lists to the Department of Justice. And then the Department of Justice said specifically, what we're going to do is we're going to take those voter lists, we're going to compare them to this SAVE database. It's a different SAVE, but it is a database that is used for other things. And ostensibly, it doesn't have anything to do with voting, doesn't really have anything to do with citizenship. It has to do with sort of people here on green cards and getting government services. But the administration is convinced that they can use this database to identify, non-citizens who are on the voter rolls, even though that has been rebutted time and time again. That's not an issue. Non-citizens voting is a 0.0000001% problem. It's never been statistically significant, has never affected the outcome of any election anywhere. But this administration is obsessed with non-citizens. And so a number of states have pushed that. That is really, I think, what the administration has pivoted to, because the point there is they want to hoover up all these voting lists, and then they want to tell the states, kick these tens to hundreds of thousands of people, purge them off your voter list. And if you don't, we're going to sue you. Several states have pushed back on that. There's, I think, 6 or 7 courts have ruled on that and said it's in it. Department of Justice doesn't have that authority. Protect Democracy, along with ACLU and Crew and Common Cause, filed a lawsuit in DC challenging the fundamental ability of DOJ to even request those files. It's fully illegal. It's not within their authority. So we filed that a couple of weeks ago, and we're actually working right now on a motion for summary judgment to try to get the judge to prevent DOJ from collecting those files, prevent DOJ from doing anything with them, from sharing with them, from using them in any way. So we are currently working on that. I was actually working on my section just before this call. So we're going to file that next week and hope for a really expedited decision. So to answer your question, I think that's what rather than the SAVE Act passing, because I think they figured out that that's not going to pass, they've pivoted to this other sort of attempt to sort of do the same thing. The idea being like kick people off the voting rolls, but there's a whole group of organizations fighting back against that as well. So we have a lot of hope for those lawsuits. I think we have really good legal theories.
And then if you have time for point 2 of that,
sure.
You mentioned the purging. Can you give clarity? Because you guys are clearing up so much that we've heard from different entities. Is there any more a purge law? And is that county specific, or is that state? As we're trying to encourage people to check their voter status, what is the official thing?
Yeah. So under the National Voter Registration Act, NVRA, states are actually required to monitor their state voter lists and purge appropriately, right? So if people die or they move to a different state, or whatever the case may be, it is a good thing and appropriate to remove those folks from the voter rolls, and that's fine. And so NVRA has specific rules around how that happens. And there is a quiet period. So part of the law is that as you get close to elections, all purges, sort of mass purges, have to stop. So you can't be kicking people off the voter rolls too close to the elections. One of the things I will say about our coordinator of elections, Mark Goins, is that he does take that responsibility pretty seriously. And in fact, when DOJ, so Tennessee did provide its voter rolls, but Coordinator Goins actually pushed back on DOJ and did not sign the memorandum of understanding that they wanted him to sign. And part of the reason was because DOJ was saying, we will send you a list of people to purge. You will purge them. And he basically said, well, the NVRA says I have limits on what I can do, what I can and can't do. And so I'm not going to sign something that says I'm just going to, salute and do whatever you tell me to do. That's not consistent with the law. So that was a small moment of bright side, I think, from our state. And so I would say it is always best practice to check and check and check again to make sure you haven't been kicked off the voter rolls, and to make sure your registration is current. You can do that through state website. There's a bunch of other partner organizations that do. So I'm hoping purging isn't going to be a huge issue in Tennessee. A little unclear. We're still early in the cycle. I think we're going to see it a lot more in some other states. So Texas, it's going to be a huge problem. Florida, it's going to be a huge problem. But we're certainly, I think, us and other groups are keeping our eyes closely on that.
Thank you so
Great
much.
question. Yeah, of course.
Okay, thank you, John. I will say that there's a lot that's going to happen over the next couple months, right? Because election commissions are implementing new districts, like that could entail polling location changes or reassignment in precincts, and so what our mission is to keep y'all and the public informed on how redistricting is going to affect like your ability to cast a ballot in August, right? And so we're going to plan on reconvening a call like this as every county kind of implements their own plan. It's kind of going to be on a rolling basis, but there are some things to like look out for in regards to voter purges with mailings, with a bunch of different stuff. So we're going to keep an eye on all of that with y'all's help. And so if you're interested in that effort, please fill out our volunteer interest form again, and I'll send a recording out after this so that y'all can reference it. Um, but we'll continue to like keep you up to date because it is a moving target and counties are making preparations for August in very real time. And their preparations, let me tell you, are not all going to be the same. And it's not going to make sense all across the state. So one of our missions is going to make sure that our poll observers who are out there in the field are documenting that so that it's really transparent and we're collecting evidence for all that stuff and that we're educating the public. So that's kind of like the two big ways we're going to be fighting back against that. So fill out the volunteer interest form, and we will find some time over the next couple of weeks to just like review how um, the special session and Supreme Court case is going to be affecting everyday voters. So that's kind of one of the clear next steps. So everyone say thank you to John again for a great presentation. A lot of feedback in the comments on like how clarifying this was. Um, and for everyone else, thank you for joining us tonight. Hope you learned something. And with that, I will let you all go. Thank you again for joining us. Keep an eye out for the recording. And then, yeah, thanks again. I will let you all go. Bye, y'all.
Adam, thanks everybody.